Ms McCarthy.
My Lord, before the short adjournment, I went through the first of my two preliminary points on context. My second point concerns the interrelation between issues 1 and 2. We say that the Court of Appeal was right to note that issue 2 is freestanding and doesn't depend on Mr. Derry succeeding on issue 1. For your reference, that's paragraph 54, core 7, page 148, MS 149. I will develop this point further in due course.
Sorry, I understood that if you win on point 1, we don't need to worry about point 2. Is that wrong?
Exactly right, my Lord. But likewise, we do not need to win on point 1 in order to succeed on point 2. I'll develop the point further in due course, but I just wanted to say at this point, there is nothing wrong in principle, and this goes to issue 2, with a self-assessment being reduced by an amount that is wrong in law. That is the entire reason that the Section 9A inquiry process exists, because HMRC receive a return, they think, oh, this looks a bit wrong to us, we're going to open an inquiry. And either they're wrong or they're right about that, but there is nothing wrong in principle with a wrong amount featuring in a self-assessment. That is why the inquiry process is there. Just for your note, we give the example of entertainment expenditure at paragraphs 63 and 64 of our written case. That's core 6, page 107, MS 108. And the point we make there is assume I have income tax to pay of 100. I reduce it by 5 because I wrongly believe that I can deduct client entertaining and my self-assessment is 95. The revenue can't take me to the county court for the other 5, rather they have to open an inquiry and so on. And if that is right, we say there's nothing wrong in principle with a claim erroneously being included or erroneously forming part of the self-assessment calculation. And indeed, that is exactly what Lord Hodge was concerned with at paragraphs 27, 28 and 34 of Cotter.
Yeah.
Can I just be sure I understand, because I'm not certain that I do understand, why if you win on issue 1, we don't need to worry about issue 2. If you win on issue 1 is whether or not Schedule 1 be applied. If it doesn't apply, then under Section 132 you have a choice of tax years in which you can claim the relief, but you still have to do so. Do some of the arguments against you about the effect of the return for 0910 not still arise?
So I suppose, my Lord, that's potentially right, but I think what we would say is this. If we are right on issue 1, then we must plainly be right in relation to how we construe the tax return entries, because in that scenario, it is absolutely clear that we have reduced our tax due in year 1, if I can call it that, by the 165 amount. And so, my Lord, I suppose that's correct. Issue 2 doesn't entirely fall away, but I think issue 2 we must be obviously right in relation to.
Yeah. Thank you.
It seems to be common ground that we don't have to worry about issue 2 if you win on issue 1. Possibly for that reason.
We would say there is no merit in HMRC's case on issue 2 if we are right on issue 1, because if we are right in issue 1, then the tax return, the tax calculation boxes cannot possibly mean anything other than we are allowed to reduce our year 1 tax, and that
No, I understand what you're saying. It sounds good sense, but I understood that Mr. Norbat to concede that if if you win on issue 1, we don't need...
Yes, my lord, I think that's correct, but I think that may be for the slightly modified reason that my lord, Lord Reid has just identified, which I think is technically correct.
I see. Okay, well, whatever.
But either way, I don't think we have a real argument about the construction of the tax return once we have won on issue 1.
Okay.
Maybe if I can put it like that, and I think that is certainly common ground. And HMRC at no point in their pleadings, their written case, or oral submissions have identified a proper basis for us losing if we are right on issue 1. So we say, just returning to the interrelation, the judgment in Cotter is clear. A claim is included in a return if it relates to that year's tax liability. That is our issue 1. Alternatively, if it doesn't, the effect of an erroneous claim can nevertheless form part of the return if the taxpayer has calculated his tax due and reduced it on that basis, and that is our issue 2. Now, here we say, not only did Mr. Derry complete the tax return, the TR pages, but he also completed the tax calculation boxes at HMRC's invitation, expressly reducing his 0910 tax due by the 165 amount. And I just want to reinforce, so far as issue 2 is concerned, it is irrelevant whether he is right or wrong in law to have done so.
So the critical entry for your purposes is which one?
So on issue 2, well, the critical return entries core volume tab 7, page 190, MS 191. The core entries are boxes 15 and 16 when read together with the rubric.
That relates back to TC2, which I think is illegible. Is that right?
I'm sorry, my lady, that relates back to TC2.
It's in the rubric, as you've called it. The reduction in tax payable in box 15 on page 2C2.
I'm sorry, is your copy illegible? I'm afraid, we don't have the same copies in that case. I'm afraid I was under the impression that legible copies had been provided.
Page, which page? On page 190, mine is legible.
Yes,
Yeah.
preceding.
I mean, the rubric at the top says adjustments for tax due. Is that what you want?
Yes, adjustments to tax due. You may need to make an adjustment to increase or decrease, etc.
Yeah, and your point is that the self-assessment is of the tax due.
Exactly right, as adjusted by box 15
Yes.
when read together with box 16.
And this is TC2. This page, if one can read it, is TC2.
It is, yes. You can see just at the bottom.
I think it is, Mary.
My lady, I think we have an unmarked clean copy, if that would be of assistance.
Thank you.
I think, my lady, that will have the hard copy numbers, but no MS numbers on it. So, okay. So it's hard copy pages 189 and 190.
Thank you.
I wonder if perhaps we could also be looking on page 183 in the hard copy at boxes 3 and 4.
Now, my lord, boxes 3 and 4, and if I can also direct your attention to page 184, box 19.
Yeah.
They are also relevant, but as you'll see from the bottom of the page in the centre, tax return additional information, these boxes are the same boxes that the taxpayer completed in the Cotter case, And so we read the Supreme Court's judgment in Cotter as suggesting completing this isn't good enough. You must also complete the tax calculation pages if you want to effect the return.
I see.
And in answer to my Lady Black's question just a moment ago, the tax calculation pages, you can see that they're the TC pages at the bottom in the centre of those pages. It's small text.
And it's talking about increasing or decreasing your tax for 2009-10.
Exactly right, my lady. And that is why we say that that can only be a reference back to total tax due in the box 1 of page TC1. And we say that these two tax calculation summary pages need to be read together, as the Court of Appeal understood. And so boxes 15 and 16, under the heading Adjustments to Tax Due, can only be a reference to total tax due per box 1. And so the self-assessment taken in the round, taken together, is the reduction in the box 1 amount by the box 15 amount, as set out very clearly in box 16.
And that is the tax within the meaning of section 191B, is it?
Well, we would say yes, but ultimately it is the tax due that was referred to by Lord Hodge in the...
Yes, but I mean where he's simply interpreting the section which requires you to make a self-assessment of section 9.
Yes.
So one's looking for something in that,
Yes.
which the form feeds into. And you said, I think both of you says section 9(1)(b).
Yes, that's quite right. Now, I'm taking my submissions a little out of order, but if I might just pick up on one matter.
Are you leaving the form?
Not yet, and that was
Okay.
the matter that I wanted to pick up on. My learned friend referred to the personal tax computation, which is on page 173, MS 174. Now, we need to be clear, it was found by the upper tribunal that this was not submitted, this page was not submitted to HMRC. Rather, it was prepared by Mr. Derry's accountants for Mr. Derry's personal use. And we say that it's entirely irrelevant where line entries on this page appeared, because ultimately all Mr. Derry is interested in is what does he have to pay or what is he expected to get back from HMRC. And the fact that the fact that his internal accountants may have performed a different computation is entirely irrelevant. So this page was not part of the tax return.
That's page 194 or 173 or both.
173 was not part of the tax return, nor was page 193, MS 194. I'm sorry. No, I'm sorry, that was wrong. Nor was page 195, MS 196, which is the equivalent tax computation for the 10-11 year.
Yes, I mean, in the hard copy, the two he referred us to page 173 and 195, and you say that neither of those were produced to the revenue.
Correct.
Well, the claim is also mentioned on hard copy page 180 in box 19. This is on page TR6. Do you have anything to say about that?
So we say that all of these pages, the TR pages and the additional information pages, were the pages that the taxpayer had completed in the Cotter case. So as Lord Hodge found, those pages were not sufficient. What really mattered was completion of the tax calculation pages.
Okay.
So we are not seeking to win this case or to uphold the decision on issue 2 by reference to anything else other than tax calculation papers.
Yeah.
But of course, all of this is consistent.
Yes. And which figure? I'm sorry, I'm asking this when we did cover it earlier, but can you remind me which figure was it that was generated by the software?
It was the box 1 figure.
Right.
And we say on that point that bearing in mind box 1 was generated by the software, it's hardly a self-assessment or a tax calculation performed by the taxpayer in any meaningful sense.
Yeah.
If that is the end product, it's self-evident that the taxpayer must be able to adjust that. And may I make another point whilst we are on these pages, and I apologise, I am taking my submissions out of order, but since we're here. My learned friend accepted, and so this is hard copy 189 MS 190, that box 11 blind person surplus allowance was something that fed into the self-assessment. And he's right about that, and we'll see that when we turn to look at the calculation in section 23. I think it feeds in at step 3. But we say it's a rather perverse position for HMRC to be taking, to say that, well, box 1 is the self-assessment and that's it. You can't possibly have boxes 15 and 16. Oh, but box 11 also counts.
Yes. Yes. So your point is you've made it as clear as the algorithm allowed you to.
Exactly right. Exactly right. So before turning on to my submissions in substance, those were the two preliminary points. My Lord, I think it might assist. You asked my learned friend right at the start of his submissions, what is the difference in practical terms for Mr. Derry, whether issue 1 or issue 2 is right? If my note is correct, HMRC's answer was, well, it's cash flow only. And whether Mr. Derry is right on issue 1 or 2, HMRC can nevertheless recover tax via their section 9A inquiry into the year 2 return, and my learned friend referred to De Silva and Nibbs. We say that's wrong. For a start, I'd like to point out that it's inconsistent with my learned friend's case in his grounds at paragraph 37. So this is core tab 1, hard copy 23, MS 23. HMRC's grounds on which they obtained permission read possible consequence of the court's holding that a section 9A inquiry should have been opened where none was opened could create more than a cash flow disadvantage. It could potentially create a loss of tax, as in the absence of a valid section 9A inquiry, the year 1 return is final. HMRC would not be able to give effect to the conclusion of its inquiry into the claim to carry back loss relief. Therefore, it's not clear what the Court of Appeal was referring to when it stated that the consequence of its decision was, and the transcript is a little incorrect here, it's at least a cash flow advantage. It appears that the decision precludes HMRC from disallowing the claim in respect of year 1 in circumstances where the Court of Appeal had concluded that HMRC had opened a valid Schedule 1A inquiry into the carryback loss claim. Now, we say that paragraph 37 of HMRC's grounds is actually a correct summary of what the answer is. Quite why they've changed their position is unclear, but on any view, we say they're wrong about that. If we're right on either issue 1 or issue 2, the result is that Mr. Derry's year 1 self-assessment of tax due is reduced. That being so, the Supreme Court's judgment in Cotter at paragraph 34 tells us that the revenue need to open a 9A inquiry. And if I could ask your Lordship to turn that up, please. That's Authorities tab 6A. Authorities tab 6A at page 452, MS 702. And in this paragraph, Lord Hodge is contemplating, if you like, both our issue 1 followed by our issue 2, where a taxpayer makes a claim for relief in a tax return form, which is on its face relevant to the year of assessment, so that's our issue 1, or where the taxpayer chooses under section 9(1) to calculate the amount of tax that he is due to pay, so that's our issue 2, and allows for relief in his calculation. The revenue, if it disagrees, will have the option of correcting the return, the year 1 return, under section 9ZB, which extends to errors of principle. If the taxpayer rejects the correction, that correction has no effect. The revenue may give notice of an inquiry under section 9A, and that is obviously into the year 1 return. Now, my learned friend tells us that De Silva and Nibs somehow mean that in fact HMRC can collect year 1 tax by way of an inquiry into the year 2 tax return. But that isn't what either of those cases say at all. In De Silva, Lord Hodge was contemplating the case where the only inquiry was a section 9A inquiry into the year 2 return. But in that case, the taxpayer was not alleging that the tax calculation pages contained a reduction in relation to year 1. So we did not there was not in De Silva the same fact pattern as there is here. My learned friend referred to the reference to box 18.9, and perhaps we might turn this up, please. So this is Authorities tab 14A. And there's reference to box 18.9 in paragraph 4, page 633, MS 884. Now, my learned friend suggested that box 18.9 referred to there was the same as box 15 that we're arguing about in this case. Unfortunately, we don't have copies to show the court, but we looked it up over lunch. That isn't correct. Box 18.9 of that relevant year's return featured on the TR pages. So that box corresponds to the same sort of entries that Mr. Cotter had made, that it did not correspond to the TC entries. So that being so, Lord Hodge could not have been contemplating a situation where HMRC can fix their failure to inquire into a year 1 return by nevertheless somehow amending the year 2 self-assessment in order to somehow claw that tax back. And that's plainly right, because as we know from section 4 of the ITA, income tax is an annual tax. It absolutely cannot be right to suggest that the revenue can fail to open an inquiry into a tax return for 1 year and say, oh, well, never mind, we can remedy the situation next year because we'll just open an inquiry into next year's tax return and somehow claw the tax back. That just can't be right. Nibs is to like effect. Nibs is exactly the same situation as De Silva. So in Nibs, they were not arguing about a year one self-assessment. Just for your note, it's Authorities tab 12, page 585, MS 836, paragraph 33, all the cases turned on a simple proposition, namely that the claimants had all made claims which could only be challenged under the procedure laid down in Schedule 1A. So that plainly isn't our case if we are right in relation to either issue 1 or issue 2. So, my Lord, I hope that answers your Lordship's question in relation to what we say the consequences are, and also deals with why we say the revenue can't be right. They were right the first time in para 37 of their grounds. So, if I may now go on to my submissions on issue 1. Just by way of overview, we say that the relevant ITA provisions operate to reduce Mr. Derry's income tax liability in 0910 and were not subject to para 2 of Schedule 1B. I have 3 propositions to make, and just for your Lordship's note, they're summarised at paragraph 35 of our written case, core 6, page 97, MS 98. Our first proposition is that on their own terms, there's a conflict between the ITA and the TMA regimes. Our second proposition is that the later, more specific regime relating to liability, i.e. the ITA regime, should take precedence over the earlier, more general regime relating to assessment. And our third proposition is the subject to para 2 of Schedule 1B wording. That provision is therefore necessary before the ITA regime can be disapplied or can be subordinated in favour of the TMA regime. And there's a degree of overlap between our second and third propositions. If we're right about that, then because here there's no subject to para 2 provision, Mr. Derry's claim was effective in law in reducing his year 1 income tax liability. If I could ask your Lordship to please take up Authorities Bundle 1. I don't intend to go through all the same provisions as my learned friend has done, but I do just want to highlight a couple, please. So the ITA regime is behind tab 2. Starting off at section 1, which is page 94, MS 344. Just to note in passing that TMA 1970 is not identified as one of the acts that makes provision about income tax. And we say that's obvious because it's a mechanical computational, a mechanical collection act rather than liability fixing act. Skipping forward then, to section 22, please, page 101, MS 351. 22.1, it's clear here that this is not simply to do with computations of tax liability at large. So this chapter is not to do with the sort of hypothetical computation that para 2.4 Schedule 1B is concerned with. This is to do with calculating an income tax liability for a tax year. Over the page then, please.
But the first of this chapter, that's. I think we were told it was chapter 3 of. Is that part 2?
I'm sorry, my lord.
This is concerned with this chapter in subsection 1. I think that's chapter 3 of part 2. Isn't it?
Yes, that's correct. Over the page then to section 23, the calculation of income tax liability. Please could I ask your lordship to turn up our computation that we've set out in our written case, so you can see how this applies to Mr. Derry's position. That is Core Bundle tab 6, page 93. MS 94. And what we've sought to do here is walk through the steps according to Mr. Derry's actual figures in his 0910 return. And so you'll see step 1 is all the various components of income. The product of that is total income, and that's the 519 figure in the right-hand column. Oh, I'm sorry, my lord, it's page 93.
Yes.
Step 2, deductions. Here we're cross-referred to section 24, and as we've already seen from section 24.1a, that again cross-refers to chapter 6 of part 4. And so we say here, this is where the share loss relief deduction should be entered. Step 3 then, including allowances, Mr. Derry has personal allowance. But if I might, just for your lordship's note, you'll see step 3 as it's worded in paragraph 23. There's the reference there to blind person's allowance, which was the point that my learned friend made. So you can see that blind person's allowance very clearly is deducted as part of the computation for the person's tax liability. I should also mention for your note, the tax return actually refers to surplus blind person's allowance, but that is where the blind person in question has surplus allowance. He or she can transfer that to her spouse, and so the box in the return for that surplus blind person's allowance is for that spouse to make the entry. But the point nevertheless is that that allowance appears section 39 of the ITA, which is under chapter 2 of part 3. So whilst the wording is slightly different, it is still a reference to something that needs to be deducted at step 3. Then step 4, you'll see all the rates are applied in order to come to the income tax due at step 5. In our case, Mr. Derry has nothing to deduct in relation to steps 6 and step 7. And the result is Mr. Derry's liability to income tax for 0910. And just looking at our computation that I've included on page 93, because he has tax at source, because he's already deducted tax at source, that comes off, and he's left with the tax refund. That is the figure that essentially is the product of the various entries in the tax calculation pages.
The figure of 414,500 is familiar, of course. Some of the other figures are not the same as in the tax return for 0910, as far as I can see.
Yes, that's correct.
Yeah.
I mean, what my learned friend is right to say that box 1 is the product of an algorithm. That is something that is populated by reference to other figures elsewhere.
I see.
But if one was doing the sums manually by hand, this is the computation that you should be performing.
Yes. So you saying, well, I'm not quite sure. So the figure of 98,650, which you arrive at as the chargeable income, I think.
Yes, to which the tax rates are then applied.
Yes. Does that correspond to the figure of the 95,546 figure?
No, it does not, because that is the tax due figure.
Ah, right.
Yes, as opposed to simply the income on which the tax rates are then applied.
Oh, yes. Yes, I see. Yes, thank you.
So there's no correlation between these figures and the figures in the actual tax return.
So some of the basic figures correlate, like, for example, the amount of employment income, the land and property income, and so on. But in terms of the computation themselves, there isn't a correlation one way or another. I say one way or another because if one were simply to remove the share loss relief at step 2, then what you're essentially doing is lifting out a deduction of tax of 165,800, and that still doesn't get you the figures in the tax return.
No.
So even if HMRC is correct, on any view, the self-assessment of 95 isn't the correct way of doing the sums.
I mean, for example, the figure for the very first figure, employment, is in your calculation in the case. It's just under 500,000. On the tax return, it's stated as a figure of just over 200,000.
So I think that is because Mr. Derry received compensation for loss of employment, which had to be taken into account.
I see.
And if I can find that briefly.
Is that the 285 figure on page AI2?
And they seem to be the same figures on page 173. But
Yes, certainly.
Yes.
Yes, I see.
and this is an exercise done by you on the basis of the figures we have at 173.
Yes.
As how you say it should have been done.
And the relevance of this computation is that you can see that when you get to the tax refund, you end up with exactly the same number as Mr. Derry anticipated that he was getting.
Yeah.
He anticipated that he was going to be getting that because he was reducing his tax due by the 165 figure.
Mm-hmm.
And just going back to our written case, at page 94, paragraph 29, so that's MS 95. My learned friend is right to say that because of the high rate of tax Mr. Derry was already paying, there are two ways of getting to the same number.
Yeah.
The correct way is by putting 414,500, taking that off at step 2. But you get to exactly the same way by deducting tax of 165,800.
Yeah.
And Mr. Derry referred to both of those figures in his box 16 tax calculation page.
Yes, so effectively you're saying that if you follow the law, the calculation looks like the one you have in your case.
Exactly right.
But the software doesn't permit you to do that when the form is completed.
Well, it is right that you don't get to any of these figures in relation to box 1,
Yeah.
but that is exactly why the tax adjustment needed to be made.
Yeah.
And if 165,800 is deducted from the 95,000, you get to the exact same tax refund as you do setting out the steps.
Yes. Yes.
Now, the point about showing you this calculation is, my lord, of course, you're already aware, and my learned friend has already taken you to the legislation. But if I could ask your lordship just to turn up quickly, we're back in the authorities, tab 2, sections 131 to 133. And this is hard copy page 122 MS 372. So 131 share loss relief sets out the eligibility criteria. But then, as we can see from section 132 on page 124, MS 374, these provisions are prescriptive. Section 132 sub 1, the claim for loss to be deducted in calculating the individual's net income. Now, that reference to net income is a direct reference back to section 23 step 2, and we see that anyway from the wording in parentheses. At 132 sub 3, the claim must specify, and as we did in our case, the previous tax year. And then 133, so this is now page 125 MS 375, how the relief works, is worded in like terms. So we say it's clear beyond doubt that if the ITA provisions are to be applied taken together, that computation anticipates the sums, the calculation that we've set out in our written case in relation to year 1, the previous year, 0910. So that is how the ITA provisions work. In contrast, under the TMA regime, we say the reverse is true. So under the ITA regime, you're looking at a deduction or a reduction in tax in year 1. Year 2 is unaltered. And my learned friend has shown you Mr. Derry's year 2 tax return already and the computation. And the one thing that is clear beyond doubt from there is there's no reference to any minus 414,500 or minus 165,800 in any of those computational pages, because Mr. Derry had far reduced income tax to pay anyway in that year. If, however, the TMA regime applies, then the loss claim has no effect on year 1 income tax liability at all, but instead, Mr. Derry's year 2 income tax liability is reduced by 165,800. And my Lady Black, I think, asked the question earlier this morning, how exactly does that work? If I could ask the court to turn up, please, Cotter Supreme Court, Authorities 6A. Paragraph 16 and 17, so that's page 448, MS 698. And 17 set out mechanistically how the TMA Para 2 regime works. Liability to pay tax in respect of year 2 is reduced. There's no alteration of the tax chargeable and payable in respect of year 1, that's 16. And in 17, because Mr. Cotter had accepted that para 2 of Schedule B applied, the claim did not, and this is the last sentence of 17, the claim did not affect the amount of tax which was chargeable or payable in relation to 0708. So that's year 1 for our purposes. There was therefore no issue between the parties as to the correct assessment to tax in that year. So pausing there, we say it's obvious that there is a conflict, an inconsistency between the sums that the ITA regime requires you to do and the sums that para 2 requires you to do. 2 further points on the language, and I think just for your note, para 2.3, the claim shall relate to the later year, and para 2.6, effect shall be given to the claim in relation to the later year, are in direct conflict, we say, with sections 1321 and 1331 of the ITA, which refer to the loss to be deducted, quotes, in calculating the individual's net income for the previous year. So it's clear from the maths that there's a conflict, it's clear from the language that there's a conflict. It's not, we say, right to suggest, as HMRC do in their written case, and this is para 42 of their written case, so core bundle tab 5, page 72, MS 73, it's not right to suggest that the ITA regime is used only for the purposes of calculating this notional amount B in para 2.4 of Schedule 1B. This is their paragraph 42. That's because it's clear from reading the ITA provisions together that they operate to reduce year 1 income tax liability. They do not operate to provide the basis for some sort of hypothetical computation to be performed elsewhere. Now, if I could ask your Lordship please to turn up paragraph 41 of our written case. So that's core at tab 6, page 99, MS 100.
Paragraph reference again?
Paragraphs 41 and 42 of our written case, page 99. Just for ease, you'll see that we set out at our paragraph 41 the Court of Appeal's finding. Now, I'm not sure what happened here, but the Court of Appeal found at paragraph 39 that there was no inconsistency between the ITA regime and the TMA regime, and they seem to suggest that we didn't challenge that. I've set out at paragraph 42, we did challenge that, by reference in particular to a subheading in our skeleton argument, which shows quite clearly we challenged it. The reason for showing you this, though, is that there is no reasoning from the Court of Appeal for me to attack as to why it is they concluded that there was no inconsistency. But my Lord, my submissions on that point, I think, should show that there is. So that now takes me to my second proposition, that the later, more specific liability regime should take precedence. And just for your note, we've set these submissions out. It's paragraphs 43 through to 53 of our written case. Core 6, pages 99 to 102, MS 100 to 103. And I have 3 submissions to make under this heading. First of all, the fixing of liability is prior to assessment, and that is the Whitney point. Second of all, obviously the ITA is later legislation, but I say it's also more specific legislation. And thirdly, from the words on the page, we say Parliament's intention is that the ITA should prevail and the TMA should be subordinate. In circumstances such as this, where you don't have the subject to para 2 wording. So starting off with the first submission, fixing of liability is prior to assessment, if I could ask your Lordship please to go to the UBS case, which is Authorities tab 18. And the first page is page 818, MS 1069. Just by way of brief outline, the UBS case concerned whether a UK branch of a Swiss bank could claim the same tax credits on distributions that it received as a UK resident company could. Lord Justice Moses delivered the leading judgment. And if I could ask your Lordship please to pick it up at paragraph 18, which is page 824, MS 1075. The first question that the Court of Appeal considered was essentially whether payment of a tax credit was part of levying tax, i.e., was it part of the imposition of liability? You'll see from paragraph 21, the quote from Whitney. So one of the reasons for taking your Lordship to this case is you'll of course recall Lord Justice Henderson said, oh well, Whitney isn't applicable these days. This case, and just for your note, the case of Walapoo, which is behind Authorities tab 19, that's a 2016 judgment of the High Court, but both of these cases illustrate that the Court is still happy to refer to the 3 stages in the imposition of a tax as set out by Whitney. Now, just reading on for a couple more paragraphs in UBS, please. At paragraph 22, the point is made that the basis of computation must form part of the first stage, the imposition of liability. Only when that basis has been identified can there be any liability. We say, pausing there in parallel, sections 23, 24, 132 and 133 of the ITA plainly concern the basis of computation and thus the imposition of liability in year 1. Moving on to paragraph 23, please. The determination of the entitlement of a company resident in the UK to a tax credit is part of the process of computation of its liability. Now, we say in parallel, so too here is the entitlement to a year 1 deduction for share loss relief. And you'll see in paragraph 23, there's the reference to entitlement depending on various qualifying factors. That's obviously the same sort of formulation as we have in relation to share loss relief. But then relevantly, at 23, just by little j, for present purposes, it is sufficient to observe that although a company will only receive a tax credit when it makes a claim, in its return under section 42(5)(a) and 10(a) TMA, ... the basis of entitlement is logically prior and forms part of the system whereby taxation is imposed. So that is exactly the point that we are making here. It doesn't matter that TMA may provide claims machinery. That in and of itself is not enough to let the revenue dive back in and recalculate liability, because that has already been fixed at the first stage.
I mean, isn't that what section 23 says?
I'm sorry, section 23.
But it tells you how a calculation of income tax liability. And takes you through
Exactly, my lord. That is exactly
7
our
steps
point.
and says what you get at the end of that is your liability to income tax.
That is
for the tax
exactly
year.
our point. And the fact that there may be subsequent mechanical provisions relating to the making of claims does not disturb liability, as was the case in UBS.
And you say section 132 feeds into section 23 calculation of liability.
Exactly right.
Unless there's something to take it out.
Exactly right. And so our point is the subject to para 2 provision is necessary in order for that ITA regime to be overridden. Now, again, just for your note, Court of Appeal, paragraph 49, Lord Justice Henderson gives 2 reasons for dismissing the Whitney analysis. First of all, he says, well, the case was 100 years ago, but I've shown the court 2 recent cases where this is applied, so we don't say that is a sound reason. And secondly, Lord Justice Henderson held that the normal provisions for calculating liability in the ITA are overridden essentially where there's a subject to para 2 provision, and now this is my paraphrasing. So what's the harm in letting the TMA provisions in? And we say that misses the key point. The key point is that express reference to para 2 Schedule 1B is required before it can be said to alter income tax liability. In other words, where it's Parliament's intention for para 2, if you like, to be brought into play, to be relevant to the income tax liability calculation, it expressly so provides. So, my lord, this is exactly our point. That subject to para 2 wording is necessary.
And you say the reference section 1020 is not enough.
Well, I was going to come on to that, but since...
Well, don't get out of your...
Okay, well, I'll leave it. But, my lord, exactly, we say it's not enough. And actually, we say section 1020 and the language used by that section is a good example of a mere signpost. That sort of provision is a mere signpost, but the subject to language is plainly not, we say.
Subordination, not a signpost.
Exactly right, my lady. Now, my second submission under this heading, ITA is later, well, obviously it is. The ITA is more specific legislation. Now, the Upper Tribunal and Court of Appeal both determined that the ITA was not more specific for essentially the same reason. And if I could ask your lordship, please, to turn up Court of Appeal paragraph 50, which is core 7, page 147. MS 148.
I'm sorry, you took us, I've been following up a reference you gave us a little earlier. You showed us paragraph 39 of the Court of Appeal, where Lord Justice Henderson approved the Upper Tribunal's consideration of paragraph 38 of whether there was an inconsistency between section 132 and Schedule 1B, and decided that there wasn't. And when you look at the reasoning of the Upper Tribunal, which is in paragraph 38, which is on page 164 in our hard copies, the reasoning is that the Tribunal looks at sections 64 and 65 of Chapter 2 and sections 128 and 129 of Chapter 5 and says that they are expressed in similar terms to section 132. It's clear that sections 64 and 128 are meant to operate in accordance with Schedule 1B. It's therefore difficult to argue with something in section 132 which is inconsistent. So the premise is there's no material difference between the wording of sections 64 and 128 on the one hand and section 132 on the other, which just ignores the evident difference that there is.
Exactly right, my lord. And in saying there's no inconsistency, leaving aside the subject to para 2 provision for 1 minute, what the upper tribunal seems to be saying is, well, the rest of the language is the same. But that ignores the real substantive point, which is there is an inconsistency when you actually apply the two different sets of provisions, because they give rise to totally different computations in relation to year 1 and year 2.
Yeah, I mean, it's clear, when it says it's clear that sections 64 and 128 are meant to operate in accordance with paragraph 2 of Schedule 1B, as the ladyship's just pointed out, what they say is that section 64 128 actually expressly tell you that they are subject to
Exactly, my lord. That is essentially our submission.
yeah.
And so, whilst I appreciate I have laboured the point about the computation, the reason is because they were essentially the same submissions that were made before the upper tribunal and the Court of Appeal. But in both cases, the point about different outcomes just seems to have been passed over without any analysis.
I'm sorry, I took you out of your order, but I thought it was perhaps worth just looking at that.
Do we have any,
My lord.
I mean, I asked whether there was any sort of explanation in the background to these provisions as to why there was this difference between employment relief and share relief. Are you able to help with that?
So we looked quite extensively before the upper tribunal, and we weren't able to find anything by way of explanatory notes, etc., which sets out why. We have, if you like, two theories. I put it no more highly than that. The first theory is the one that my learned friend referred to. The Court of Appeal decision in Blackburn and Keeling concerned the old Section 380 provision. If HMRC, through its instructions to the parliamentary draftsman, wanted to preserve that outcome, that is an explanation for why you find the subject to paragraphs appearing in relation to employment and trading losses, because 380 was split into two separate chapters for both of those. The other reason we say, and I think this is more in relation to us saying there's no evidence that it wasn't Parliament's intention, bearing in mind that share loss relief is in relation to EIS companies and the like, there might have been, we don't know, but there might have been some intention to incentivise investments in those companies by accelerating the time at which you could have loss relief if those companies failed. Now, I state that reason not because we can find anywhere that expressly tells us that's a reason, but I put it in terms of it's not obvious to us that Parliament didn't intend the ITA to prevail.
But the predecessor of Section 132 was what? That was section...
So maybe, my lord, if I could ask your lordship to please turn up. We prepared a speaking note setting out the legislative history before the upper tribunal. That is in core tab 7. And it starts on page 233, MS 234.
Well, maybe, I mean, I don't want to take you out of your order. I mean, you both looked at it and obviously found nothing which helped, so I assume...
Exactly, but my lord, it's probably worth showing your lordship this at this stage. So, MS 234, so this is the first part of our speaking, this is our speaking note before the upper tribunal.
The bundle page again?
I'm sorry.
The bundle page?
235. So, sorry, page 1 of the speaking note is on 233. The paragraph that I was going to take your lordship to is at page 235. This, I think, came up earlier in one of my Lord Reed's questions. The table at the top of page 235, essentially seeks to trace through the old legislation into the new legislation. And the exercise that we did here in relation to the third column was to identify all of the new provisions, and you'll see that it's very striking. We say where the draftsman intended the new provisions to be subordinate to the TMA, the draftsman expressly said so. So in the old provisions, you'll find none of the subject to wording. But we say that that is because the old ICTA regime did not set out any clear basis for computing income tax liability. So it wasn't necessary to have that sort of subject to wording because the two provisions could operate together, see Blackburn and Keeling. However, into the brave new world of everything being clear and simple and well set out, the ITA regime, and indeed Atoya, you'll see, as we demonstrate in the right-hand column, that there is the subject to wording in various different places. If I can just pick up on a couple of points, our footnote 2 is a note saying, note, Chapter 3 of Part 4 is not a separate relief, rather it contains restrictions to trade loss relief. I think, my Lord Reid, that was a question you asked in the morning. Mm-hmm. Just then looking at Chapter 4 of Part 4, property loss relief, Para 2 of Schedule 1B is irrelevant because property loss relief can be carried forward or used sideways or post-cessation relief. So it wasn't possible to carry it back. Chapter 7 of Part 4, miscellaneous transactions, that concerned relief arising and being used in the same year or carried forward. So there was no need to have, Schedule 1B Para 2 wasn't relevant to those two reliefs.
No, but you've also got to remember, I mean, the first column are ICTA 1988, and the relevant bit of Schedule 1B to TMA doesn't come in until 1996. So you wouldn't have expected ICTA 1988 to have anything subject to that. If anything, you would have expected the 1996 legislation to have made some provision to link the two together.
And we couldn't find any such
No, that's what I assumed. Yeah, thank you.
And so just maybe if I might suggest that if your Lordship does want any further consideration of the history, we've set this out at paragraphs 11 through to 21.
Yeah.
And just picking up at paragraph 11, we looked over the short adjournment, and I'm pretty sure I looked at the time and couldn't find anything, but anything relevant in the explanatory notes about the ITA new computation. We couldn't find anything there, but what we've got at paragraph 11, so this is hard copy page 263 MS, 236 MS 237. We've got an extract from Simon's. That extract is in the bundle, the authorities bundle behind tab 25, but no need to turn it up for the moment, because you'll see that certainly so far as Simon's is concerned, with effect from 0708, ITA rewrites these provisions to make it clearer that the tax bands apply after deductions from total income. Now, previously that wasn't clear, and so for want of a better word, the revenue had to fudge it. HMRC, perhaps sensibly before 0708, ignored statutory terms and referred instead to net statutory income, etc. So, bearing in mind that the ITA provisions are supposed to be clear, are supposed to resolve previous uncertainty, we say that it would be astonishing if the draftsman of ITA 2007 was perfectly happy for old assessment regimes to somehow upset the determination of income tax liability without clear words. So, just returning then to my second submission, ITA is later more specific legislation. I think I had begun this by asking the court to turn to paragraph 50 of the Court of Appeal's judgment. So that's core 7, page 147. And that's MS 148. Now, in summary, in relation to paragraph 50, Lord Justice Henderson compared sections 23 and 24 of the 07 Act with paragraph 2 of Schedule 1B. And he said, well, when you compare the two, they're both pretty specific. 23 and 24 provide a specific regime for the deduction of reliefs, and Para 2 provides a specific regime for loss carryback. But with respect to the Court of Appeal, that isn't the right comparator. The right comparator to paragraph 2 is sections 23 and 24, when they are read together with sections 132 and 133. And when we went through the sections earlier, you'll see that section 23 expressly referred to section 24, which in turn expressly referred to the loss relief claim provisions. Section 132 sub 1 expressly refers back to step 2 of the calculation in section 23. So we say that those four provisions need to be considered holistically, and when they are, we say that the result is plainly that the ITA provisions provide a specific regime for carrying back a year 2 share loss relief claim to year 1. Necessarily, that is more specific than the rules in Para 2 of Schedule 1B, because they just refer to any carryback claims, whatever the subject matter. So we say the Court of Appeal was wrong on specificity. Moving on then to my third submission, Parliament's intention that the ITA should prevail and TMA should be subordinate. I've already made some points as I've gone through my first two submissions on that. Also, Court of Appeal paragraph 50, the Court of Appeal accepts that the ITA was introduced to replace the previous unclear computational regime, and that is just above, well, it's about a third to a half of the way down of paragraph 50. I've already shown your lordship the Simons taxes extract, which confirms that. The introduction of the ITA clarified the position by making it clear not only the stage at which deductions were to be brought into the calculation, but also which year the calculation was to be referred to. So it can't be the case that in 2007 Parliament intended for those clear provisions to be overridden without plain words to the contrary. And we say that there are two clues in section 42 TMA which accept the possibility that section 42 and thus schedule 1B might not apply in all circumstances. So this was my Lady Arden's point about default. If I could ask your lordship to please go to Authorities tab 1, pages 31 and 32. MS 281 to 282.
What are we looking at?
We're looking at section 42 of the TMA. So The first clear sign, or the first clue we say, is section 42.1, and this I'm picking up on the unless otherwise provided wording. We say that there's no reason why Parliament cannot disapply section 42 in part, and in any event, we say that section 42 must be disapplied to the extent that it's inconsistent with the ITA. It's not a case of the court having to read in the words to the extent that. We say it's necessarily implied. So that's 42.1. And then in terms of 42.11a, we say that the Court of Appeal and Tribunal construed this paragraph far too narrowly. Schedule 1B to this Act shall have effect as respects certain claims for relief involving 2 or more years of assessment. Now, we say that that section doesn't apply in the case of share loss relief by necessary implication. Specifically, we do not need any sort of express provision written into the ITA to say, oh, for the avoidance of doubt, section 42.11a doesn't apply and therefore nor does para 2 of Schedule 1B. And so that brings me on to my third proposition under this subheading, which is that the subject to para 2 wording is therefore necessary for the ITA regime to be disapplied in favour of the TMA regime. And just for your Lordship's note, that's paragraphs 54 to 58 of our written case, Core 6, pages 102 to 105, MS 103 to 106. I don't intend, given the time, to say anything more on the legislative history, but it's set out at para 54 of our written case and also in the speaking note. I've already shown the court the para 7 table of our speaking note, so that was the table that set out all the rewritten provisions, and we say that this shows that wherever a rewritten provision is to be subject to para 2, the draftsman expressly says so. And so, pausing there, having established a conflict between how the two regimes operate on their own terms, and having established that the ITA should prevail on normal principles of construction, we say it isn't open to the court simply to read in a subject to para 2 provision where it doesn't exist, and so therefore it follows that provision is necessary. Picking up my Lord Carnwath's point earlier on, it isn't mere signposting, and we would compare that to the wording of section 1020 of the ITA. And in particular, if I could ask your Lordship please to turn it up, its authorities tab to page 156. MS 406. On any view, we'll see that there is no express reference even in this signpost to section 42.11a or to schedule 1b. Now, I've already made the point. We don't know what the policy reason was for omitting those words. There may well have been a policy reason in order to encourage enterprise and be more generous in relation to share loss relief. But even if, so there's certainly no evidence that that wording is an oversight, but even if it was an oversight, then we say it still isn't permissible anyway for the court to read in a provision, because the terms of the ITA work perfectly well on their own, there's no manifest absurdity, as I've shown the court, by omitting any reference to para 2 of Schedule 1B. And I don't intend to turn them up, bearing in mind the time, but we've included in the bundle the case of Greenweb, and for your note it would be paragraphs 28 to 30 of that case, Authorities tab 9 at pages 553 to 555, MS 804 to 806, which summarises the key passages from Stock and Frank Jones. We've also included, and again for your note, the case of Inco. The relevant page, the internal page in that case, is 592A to H, and that's at Authorities Bundle 10, page 564, MS 815, and they set out what I think is well-established law. The cases on which the court can step in to cure an absurdity, and it's not legislating, it's mere interpretation, but those factors do not exist here. Picking up on one point that HMRC made in their oral submissions, if I've got this down correctly, I think HMRC suggested that paragraph 2 to Schedule 1B is necessary because you need para 2.1, which disapplies section 42.2, requiring a claim in a return. Now, I think at one point that was one of my learned friends' submissions. We say, well, actually, that's entirely irrelevant. If we are right about how the ITA operates, and that the ITA takes precedence, and that its operation leads to a deduction in relation to year 1 tax liability, then necessarily you would expect that claim to be in the year 1 tax return, to be in a return. So we don't need the disapplication of the provision requiring the claim to be in a return in the first place. Works perfectly well as a consistent whole. And in that situation, if the claim is made in the return and if it affects your year 1 tax liability, HMRC need to open a Section 9A inquiry, and it's as simple as that. Now, that comes to the end of my submissions in relation to issue 1. I've addressed the Court of Appeal's reasoning and why we say it's wrong on issue 1 as I've gone along. We say there's nothing in HMRC's points either. I've addressed some of their oral submissions as I've gone along just now. And also, what we say about HMRC's written case is included in our written case. And just for the reference, that is tab 6, page 105, MS 106, and paragraph 59. Before I move on to issue 2, can I assist your Lordship with any further questions on issue 1?
I don't think so.
Thank you. In that case, I'll move on to issue 2. I think in my introduction, I've already dealt with the situation, how issue 2 might be modified in a world in which we've won on issue 1. These submissions are focused on upholding the Court of Appeal's reasoning. If the court is against us on issue 1, then the position is that Mr. Derry's carryback loss claim in law reduces his year 2 and not year 1 tax liabilities. That's the premise. The question nevertheless arises as to whether Mr. Derry took account of the claim when he performed his self-assessment tax calculation for year 1, and we say he plainly did. I don't intend to repeat all the submissions I made by way of opening, because I think we spent some time there looking at the tax calculation summary. But if I may just summarise our submission on this, Mr. Derry completed the tax calculation summary pages and included in those pages a reduction in tax due on account of share loss relief, specifically at the invitation of HMRC. It is not for HMRC now to say, well, the boxes can't possibly mean what the Court of Appeal says they mean, because actually, and I will show your lordship this, it's clear from the historic HMRC manual guidance that HMRC, or certainly some of HMRC, considered that relief could reduce year one in that way. I've already made my submission on why HMRC can't be right to say, well, it's box 1 and box 1 only. And that's because when you look down to box 11 and see blind person's allowance, that's clearly part of the year 1 tax liability computation. So now if we're including box 11, why are we not also including boxes 15 and 16? So if we lose on issue 1 and the claim is outside the return, we say it's nevertheless been given effect to by Mr. Derry because he has chosen to reduce his year 1 income tax liability. If HMRC wishes to reverse that effect, then HMRC needs to open a Section 9A inquiry into the return. And we say that that's obvious, because at this point, HMRC's problem, HMRC's concern, is with his year 1 tax liability. And if that is so, it's a 9A inquiry. There's nothing in HMRC's point about them having to raise both a 9A inquiry into the year 1 return, as well as a Schedule 1A inquiry. It's not, and HMRC are wrong about this, it's not about making 2 different inquiries into 1 claim. That's not the point that the Court of Appeal was driving at. Rather, HMRC wished to correct 2 different matters. First of all, they wish to reduce a standalone claim from 165,800 to nil. If that is what they want to do, then they need to open a Schedule 1A inquiry into that claim, close their inquiry and make that amendment to the claim. But secondly, if we're right about the interpretation of the self-assessment, HMRC wishes to increase the self-assessment from minus 70,000 to 95,000. We say it goes without saying that they can only make that amendment if they have first opened a Section 9A inquiry into the return itself. And this is exactly what we say Lord Hodge recognised in Cotter at paragraphs 27, 28 and 34. I would like to go briefly, if I can, to Cotter, Supreme Court, HMRC's published guidance, Cotter Court of Appeal, and then to address some of HMRC's submissions. So if I may start off with Cotter Supreme Court, please. That's Authorities tab 6A. First page is page 443, MS 693. And if I may pick up on a few key points in the judgment, please. The first point that we would note is, so far as we can see, nowhere is it recorded in either the Supreme Court or the Court of Appeal's judgments, and we don't have the High Courts with us, that Mr. Cotter filled out paper returns. So my learned friend seemed to suggest that because the Cotter case concerned paper returns, this in some way assists him. So far as we can see it, that isn't correct. But on any view, there's certainly no reference to the relevance of paper returns anywhere in the judgment. Next point, we say it's clear from paragraphs 3 and 4, so this is page 446 MS 696, that Mr. Cotter did not complete TC pages. What he completed were certain TR pages and the additional information pages. And so far as we can discern, those pages were completed by Mr. Cotter in much the same way that Mr. Derry has completed his Year 1 tax return. Now, moving on to paragraph 7, critically, because Mr. Cotter had not calculated his own tax, HMRC did it for him. But because they were doing the calculation, it was up to them to work out what number they were going to calculate his tax as, and they issued a calculation of tax due that was not reduced by the amount of the loss claim. That's paragraph 7. Now, over the page, paragraphs 20 and 21, that's at the bottom of page 449, MS 699, the Supreme Court recited the taxpayer's simple argument, well, it's included in the return if it's on the face of the return, but went on to identify that if it were correct, and this is over the page in paragraph 21, it exposes HMRC to irrelevant claims which have no merit and will only serve to postpone tax payable. Now, pausing there, we find this justification a little difficult, and we certainly wouldn't suggest that it is a basis for interpreting the tax calculation pages as HMRC suggest, for two reasons. If claims are believed to have no merit, or the taxpayer doesn't take reasonable care in making claims, then the taxpayer is exposed to penalties. So it isn't in a taxpayer's interest to insert unmeritorious claims willy-nilly. Secondly, the postponement of tax payable point is equally true of, say, sideways loss relief claims. Tax is postponed in relation to the year in question. Now, obviously, there is an added benefit of being able to postpone tax in a prior year, but it shouldn't be forgotten that the moment a claim is included on the face of a return, e.g. for sideways loss, there's postponement anyway. At paragraph 23, Lord Hodge identifies 5 relevant factors, and that the simple point to make is none of them exist here. At paragraph 24, which contains the thrust of the decision, the point that Lord Hodge is making is that where HMRC has been left to calculate tax payable, HMRC is not obliged to reflect in that calculation that it is performing erroneous carryback claims. Indeed, and this is the point being made at paragraph 25, on the facts of Cotter, HMRC were right not to do so, and that is because there was the subject to para 2 wording. Now, paragraphs 27 and 28 are crucial. This is, we say, essentially what Mr. Derry has done. And when you look at the words above box 1, and you read them together with the words elsewhere on the tax calculation pages, we agree with the Court of Appeal's determination. It's an impossible contention for the revenue to say that those words mean something other than what they say. And I've already pointed out paragraph 34, which is how the system works in a world in which, one way or another, the self-assessment in year 1 has been affected by the loss relief claim.
Am I right? I mean, the section 9(3)(a) says that an assessment made by the revenue is treated as a self-assessment.
Section 9(3)(a) of the
Of the
TMA.
tax
Yes,
management, yes.
yes, my lord, that's correct.
So it shouldn't matter whether it's actually done by the revenue or by the taxpayer. The difference is that the revenue will probably get it right, whereas the taxpayer may not.
The difference is that if it's up to the revenue, they will calculate the tax according to their view of the law.
But in terms of the sort of the nature of the exercise, it's the same thing.
Yes, absolutely.
I mean, I don't think it's...
Yes. The difference is simply what happens in practice. In practice, understandably, if you leave HMRC to calculate the tax, HMRC will do that according to their view of the law. If it doesn't accord with your view of the law, and you've let HMRC do the tax calculation, well, that's just too bad.
Yes, but if you do it, then your point is, well, you may have made mistakes, factual or legal.
Yes.
But then they better challenge it.
Exactly. And that is exactly the same, irrespective of whether or not we're talking about claims, client entertainment expenditure, any entry on the tax return form. The taxpayer could get any of those entries wrong in law. Well, that's what the inquiry
What is
process
the provision which, I mean, I can see that point, but assuming that in a case like this, that they're right on the law and you were wrong, what is the provision which stops them having another go in the right year?
I'm sorry, having another go in
Another go in the legally correct year.
Well, their problem is that income tax is an annual tax.
Yes.
And what has happened if we are right about the boxes of the self-assessment is in year one, using hypothetical figures, say Mr. Derry should have paid tax of 100 because he had employment income. Yeah. In year one, however, we have used loss relief to reduce it to tax of 0. Now look to see what's happened in year two. Well, in year two, as it happens, Mr. Derry only has employment income of 10, tax of 10. It would be anathema, we say, for the revenue basically to seek to collect year one employment income by amending and increasing of the year two
There's not a
tax
provision,
return.
it's a principle of anathema.
Well, the principle is that tax is an annual tax. Okay. And so the moment that year one self-assessment is calculated, it's closed. If the revenue want to do anything with year one, they have Section 9A inquiries, they have their discovery assessment provisions.
Yeah, all right, well, I understand. I mean, they're saying they can still do it in year two.
Which there is absolutely no authority.
You're saying they weren't saying that in their grounds, but they are now.
Well, we're saying that, well, yes, that's absolutely right. They weren't saying it in their grounds, they are now. They're basing their submission on De Silva and Nibs. But in neither of those cases was the court concerned with a world in which year one self-assessment was 0, not 100. Yeah. So the court was not saying, oh, well, never mind, you missed your chance on year one, dip into year two. Because what would really be happening there is the revenue would be seeking to amend a year two return, essentially to say, well, we all know that you should have paid more tax on your employment income in year one. We're going to pretend that your year two employment income is higher so that we can get that tax back from you. That just can't be right.
Right. Thank you.
They may say, oh no, all we're doing is seeking to reverse the effect of a claim. But if you think about it computationally, what has happened, yes, there's been a repayment, but Mr. Derry has also not paid tax on certain amounts of year one income. You simply can't reach into a year two tax return and try and pull that up into the year two income figures. That just can't be right. I mentioned that HMRC have published guidance that suggests on any view that we're right about the share loss carryback provisions. And these are in Authorities Bundle at tabs 23 and 24. Now, if I could start with tab 23, so that's tab 23, page 940, MS 1191.
And what's the point of taking us to this revenue guidance?
I'm sorry?
What's the point of taking us to revenues
Well,
documents?
what your lordship will see behind tabs 23 and 24 is that certainly in the revenue's own guidance, they anticipated that losses could be used in exactly the way that Mr. Derry sought to do in his TC pages.
Yes.
So the reason for showing you these sections is simply to say it doesn't lie in HMRC's mouth now to say, oh, those TC boxes can't possibly mean what Mr. Derry says, because actually their own contemporaneous guidance show that certainly someone at the revenue believed that that was exactly how the loss relief provisions worked.
I see.
I don't intend to go through these in any great detail, but if I might just give you the relevant dates, you'll see in relation to tab 23, this has been taken from the National Archives. It's taken from HMRC's public guidance in their venture capital manual in April 2012. This is the first such occasion after that manual had been updated to address the provisions in ITA 2007. So prior to that, this manual referred to the old ICTA provisions, but this is the first time we see ITA 2007. And I won't go through this in detail now, but essentially you'll see the references to the years in which share loss relief is to be given, and it is clear from the two examples that this page of the manual anticipates year one tax being reduced in exactly the way that we've claimed.
Yeah.
And then authorities tab 24. This page is an arc.
So this has been drafted on the assumption that Schedule 1B doesn't, or without reference to Schedule 1B.
Yes, that's right.
Yeah.
Yes, so it's on the assumption that Schedule 1B doesn't apply. Obviously, though, we're not seeking to refer to HMRC's guidance to prove our point on liability. Rather, it's in connection with the boxes. Authorities Bundle, tab 24, page 942, MS 1193. This is an archive of published guidance from the website taken on 3rd of February 2011. We know that it was published on HMRC's website from at least 1st of August 2008, and it's still there now. And so it was current guidance at the time of Mr. Derry's 9/10 return. So whilst tab 23 wasn't current per se, at the time of Mr. Derry's return, that equivalent page still referred to the ICTA rules, which was obviously wrong. That page is the very first time we see the ITA rules being introduced. And again, you'll see making inquiries into claims. Actually, this page foresees that HMRC has to be careful in relation to which inquiry procedure it uses. And if I just might direct your attention underneath the bullet points, the paragraph starting at 30th of November 2006, when the 056 return is filed, it's still possible for the taxpayer to amend his return under section 9ZA. As that is so, the claim is treated as an amendment to the return for 0405, and an inquiry may be opened under section 9A. Essentially, this guidance is clearly wrong post-Cotter, but it's nonetheless interesting to note that certainly, again, certain parts of HMRC considered, if you like, the Court of Appeal's analysis in Cotter to be entirely on the money.
And in the first example, at the top of the note, it envisages a loss being claimed by being put into the additional information box.
Yes, my lord, that's right. Yes, and clearly this is wrong post-Cotter, but we still make the point about HMRC making a deliberate invitation through the wording of the tax return, which Mr. Derry has taken them up on, in particular in filling out his tax computation, his tax calculation pages. The last case that I wanted to go to briefly, if I may, please, is the Court of Appeal's judgment in Cotter. And this is Authorities tab 6B, internal page 454. Now, we know, of course, that the judgment was overturned by the Supreme Court, but the reason for showing Your Lordship this judgment is because we say that the observations that the Court of Appeal, and it was Lady Arden's judgment, the observations that the Court of Appeal made in relation to the TR pages, we say are nevertheless highly relevant when you now read this alongside the TC pages, which is what we have completed. So the relevant paragraphs, please, are 24 through to 26. And this is in relation to the TR pages, but we would make essentially the same submission as what is set out here in relation to the TC pages. The relevant boxes permit the appellant to make a loss relief claim if he chose to do so. The Revenue don't contend that we filled the form in wrong. Paragraph 25, the Revenue's argument amounts to saying that despite apparently being permitted to insert the information which he inserted in his return, the appellant was in fact not to be treated as having done so because the relevant statutory provisions did not permit him to claim relief for loss incurred in 1 year against liability to tax for an earlier year. On this argument, the form was wrong to give him this opportunity. That is correct in relation to boxes 15 and 16 if we have lost on ground 1. 26, if the Revenue is correct, then the taxpayer has to go back behind the return and ask whether he's entitled to make a claim, etc., etc. That would impose an intolerable burden on taxpayers. Now, we say that is obviously an apposite submission to make in relation to the TC pages. It simply cannot be that the Revenue invites Mr. Derry to reduce his tax due only for the Revenue to turn around and say, notwithstanding that you apparently have reduced your tax due, actually, you haven't after all. And the Revenue simply can't do that. We would also point out at paragraph 30 over the page, that's page 461, the Revenue in Cotter complained about operational difficulties, but the very apt point is made in paragraph 30, we'll just open protective inquiries. And then at paragraph 32, at the last sentence, it's up to the Revenue, if it wishes to achieve the contrary result, to make sure that the form of return does not permit such a claim to be made. And we would say that that is absolutely entirely appropriate when said about boxes 15 and 16 on the tax calculation page. But actually, are the Revenue, well, the Revenue certainly today are saying those boxes are wrong, but when you look elsewhere on the Revenue's published guidance, actually that guidance rather suggests the boxes are in the right place and Mr. Derry made correct use of them. One moment, if I may. My Lord, unless I can assist Your Lordship further, those are our submissions.
Thank you very much indeed,
Thank you.
Ms McCarthy. Mr Ripley, do you follow? Mr Norbert?
Thank you. Lord, can I take the issues then in the order?
Yes.
perhaps more conventional order, issue 1 and then issue 2. As stated earlier, we do simply rely on the comprehensive reasoning of both the upper tribunal and the Court of Appeal on issue 1. Both comprehensively dealt with all of the arguments my learned friend has addressed to you, and we say address them correctly. Moreover, as identified in paragraph 41 of the upper tribunal's decision, the Supreme Court's decision in Cotter itself is a strong, in the words of the upper tribunal, a strong pointer to the correctness of our conclusion, where Lord Hodge considered that the same provision we rely on, section 4211A, duplicates and therefore has the same effect as the, in that case, section 128 sub 7 signpost. And I say, this is paragraph 41 of the upper tribunal. I showed you the paragraph in Lord Hodge's speech earlier, but I'm just giving you the reference in the upper tribunal's decision, where they noted that it was not binding because, of course, this wasn't the central issue in Cotter because you had the express signpost, but Lord Hodge was clear that he felt that section 4211A duplicates the signpost, has the same effect as the signpost. Can I then address a question that Lord Carnworth raised, which was he was asking questions about the pre-2007 ITA position. And this is significant because, of course, the Income Tax Act was part of the tax law rewrite. It wasn't intended to change the law. And the position prior to the ITA was that trade losses and employment losses were covered by section 380 of ICTA, and share relief was covered by section 574 of ICTA. Neither contained an express signpost or a provision subjecting those provisions to Schedule 1B. However,
it didn't exist at the time.
Which one's that, sorry?
Schedule 1B didn't exist at the time ICTA 1988 was passed.
No, but by the time, but there is a period through which the two coexisted.
Yes, but we don't know which might have. That was what I was asking.
Yeah, but during that period prior, the law prior to the enactment of the tax law rewrite in 2007, the law was that you had the ICTA provisions and the TMA provisions coexisting and working in tandem. So Schedule 1...
I assume so. I just wanted to be satisfied that there wasn't anything in the pre-2007 law which distinguished between them.
Not that I'm aware. That's what...
It's not whether you're aware of it, it's whether there is.
Yeah.
But I mean, perhaps someone could...
I don't think either party is suggesting that there is.
If someone could have a look at that.
Yeah.
I mean, it may not matter, but I would prefer to take it after research rather than on the basis of you telling me.
Are we entitled to look at that?
Well, that's another question.
Well, so you've got section 380 and you've got section 574. Do you have them?
Yes, look, I don't want to take up time now.
Yeah.
I don't think it probably isn't relevant, as my lady has said, but I would be interested to know whether there's any difference. But I don't think it does affect the arguments in this case.
But when you say that the ITA wasn't intended to change the law, do you know, it's usually at the long title tells you whether it's a consolidation statute or whether it is also intended to make some amendments.
Yeah, and normally where it does, it's in the explanatory
I mean, this
notes.
is a quite different type. If we're going to go into that, we'll need a lot more information.
Yeah.
This wasn't a consolidation exercise. It was a rewrite, the purpose of which was to make things simpler.
Yes.
But to what extent it was expected to make changes, we simply don't have any information.
Normally you'd see that in the explanatory note, though.
Well,
right?
you might or might not, and we haven't got them.
But as I say, in terms of the conflict, we rely on paragraph 50 of the Court of Appeal that addresses all of these arguments. And we are in the position where my own friends and my submissions are the converse of each other. I say you need words of exclusion. She says you need express words of incorporation.
Very short point.
In terms of the acceleration reason, my learned friend sort of suggests that possibly there might be an acceleration reason, but of course the point of Schedule 1A is it provides for the acceleration, even if we know that Schedule 1A applies to employment loss and trading losses, and the effect of Schedule 1A in respect of those losses is to accelerate the receipt of those losses. Therefore, that can't be a reason for distinguishing, because it was intended that all three would be accelerated. Oh, yes, thank you. My friend is just showing me the heading, I think, that Lord Reid was asking about in terms of 2007.
I recognise, of course, Lord Carnwath's point. I was barking up the wrong tree.
Can I just read it anyway? An act to restate with minor changes certain enactments relating to income tax and for connected purposes. My learned friend said that effectively there were 4 provisions in the ITA that, viewed holistically, she said, lead to a specific regime for carrying back for a share loss relief. But it's as I sought to demonstrate, it's exactly the same 4 provisions in almost identical terms that you have in respect of the employment loss provision, for example, with the only difference being that signpost. And so in my submission, that's an important point. Can I then just deal with issue 2? First of all, the issue regarding was Cotter a paper return or not. We know that it must have been a paper return because he could only calculate his own liability to income and capital gains tax if he had completed a paper return. If he had completed an electronic return, the online return automatically populates the box 1 and box 2 figures. So that's why we know that it must be a paper return. As regards the personal tax computation, in my submission this is significant. Because up until the Supreme Court, it's my learned friends who have been seeking to rely on that personal tax computation to show what Mr. Derry understood that he was doing. That's the reason why in the upper tribunal there was this argument about did it or did it not form part of the tax return that was submitted. Now, and we know from the Court of Appeal's judgment that the Court of Appeal relied upon that personal tax computation to demonstrate that Mr. Derry was intending to set off to claim the loss back against his self-assessment, his Section 91B self-assessment. So it's ironic now that they seek to say, oh, well, no, it's not really relevant because it wasn't prepared for HMRC's purposes, but rather it was prepared for Mr. Derry's own personal use. But of course the point is that it shows you, and this is what was being argued below, and it's certainly what the Court of Appeal relied on, was it shows you what Mr. Derry's accountants understood they were doing. They understood that they were doing the calculation, computation that we say they were doing, not the computation that my learned friends say they were doing. And that's demonstrated by that page in, I think it's paragraph 28 of their case, where they seek to recreate the world where Mr. Derry had carried out, or his accountants had carried out the computation that they said he did, which moves the loss figure not from being a 2010-11 tax repayment claim now, it moves it up to step 2, so that it forms part of the self-assessment chargeability computation. So I say that's significant. I do also say, my own friend says it's not in a taxpayer's interest to insert incorrect claims, but the court should be aware that there are other cases, and that 2 of them are referred to in my learned friend's case, the case of Atherton and Tooth, where in this type of situation, taxpayers, because the form doesn't let you do it, taxpayers have sought to force in the year 2 loss into the self-assessment pages by putting them in incorrect boxes. So, for example, they'll put an employment loss in a partnership page box so that it feeds into the self-assessment calculation. Was the payment made in error was the question I was asked by my lords. Can I give you a reference? It's MS 86 and it's bound volume 85 because that's an appendix to our written case that shows that Mr. Derry's running statement of account, which shows the freestanding credit, how it worked, how it was implemented. You see that, it's on the right-hand side. Mm-hmm. But also, and that it's the running account is shown by you've got the later years payments on account.
Is this explained in Mr. Dean's evidence?
Yes, that's something I was going to ask you. I was going to move on to. I was going to ask if you could read, I'm afraid, his witness statement because it's relevant to it. It is important context, and it does explain the freestanding credit, and it also explains the issue about how it was applied and this question of error or not.
So would you like to give us the pages for that?
Of Mr. Dean's statement.
Yes, please.
Of course, a key one is paragraph 16. I would say, though, that paragraphs 4 right through to sort of that background section from 4 onwards is very helpful in terms of understanding the return, how it's completed. But 8 deals with the different payments, the 59A payments, the 59B payments. As I say, paragraph 16 deals with this freestanding credit point and how it was applied. Then also, paragraphs 21 also deals with the computer programs and how that works, and indeed the software that the accountants use. 26 deals with the white spaces. And then you'll see it's 29 onwards that deals with the repayment issue, what happened in Mr. Derry's case, and why it happened. My learned friend said that box 1 is the total tax due. What else can box 15 be doing other than reducing the figure in box 1? But what she failed to engage with is the other boxes that I identified. Box 15 doesn't appear on its own. Box 15 is one of 3 boxes. And as I said in my earlier submissions, box 13 and 14, on any view, cannot feed in to the self-assessment for the year. They're dealing with earlier years, adjustments relating to earlier years. Moreover, box 15 itself doesn't say tax loss, it says, or the losses carried back, it says repayment. So it's dealing with the 2010-11 repayment. Box 16, the explanation, a point that you weren't taken to is that the first part deals with the carryback loss. The second part deals with the claim to reduce the year 2 payments on account. So if my learned friend is right, in that same box, you've got 2 entries, same explanation box. You've got 2 entries based on a different premise. One based on a self-assessment of -70, one based on a self-assessment of a positive figure, i.e. is not based on this the tax being set up reduced against the self-assessment.
Now, Mr. Norbert, you're going to have to draw to a close pretty quickly.
Can I say the blind person's allowance? The difference between the blind person's allowance and the box 15 repayment is twofold. One, these allowances are actually claimed in the substantive pages of the tax return. That's where the claim is. But the second thing is that legally they feed into the chargeability. Whereas if we're right on issue 1, then legally box 15 does not feed into the self-assessment. And I've taken you through all the other boxes that don't feed into the self-assessment. My learned friend says about this issue about whether if we're wrong, can we recover anyway, or can we remedy the situation through the Year 2 Section 9A inquiry? What I would say is our written case predated the Supreme Court judgment in De Silva and Nibbs, and the High Court judgment in Nibbs. There is clearly an issue between us as to what those judgments say in their application. And so what that...
When you say written case, you mean your grounds?
Yes. And so all the debate demonstrates is that actually both issues are important. Because if I'm wrong, and my learned friend is right, then it does have both issues, your decision on both issues would have important consequences. Was there anything specific that I've not addressed that you would like me to address?
I don't think so, Mr. Norbert. I think we've been pretty comprehensively addressed on what at first sight looked like quite a short point of statutory interpretation. So thank you very much indeed. Well, we're most grateful to counsel on both sides for their lucid explanations, as lucid as the material permits, and also to those sitting behind them for their involvement in preparing the cases. Now, I say we're grateful for the succinctness of the parties' written cases. We will let you have our decision as soon as we can. Good, we're adjourned.